But first of all, let's think about what data is before discussing B2B data sharing. You probably know most of the standard analogies that have been used to describe data. The most well-known one is oil. And in that case, obviously, there is a possibility to own data if data would be like oil. Many companies have emphasized that it's a new oil. That's in the press as well, but I think we have to be very careful with this analogy. Others are probably better, and you know, there have been some analogy with electricity. It's interesting and important because I think data are delivered on networks today. So there is a similarity there, and concerning the regulation, that might as well be interesting. There are other analogies, as you might know. Data has been compared to light, or it's water, or the ether. It has been considered as well, as you know, as the new currency of the digital economy. We could discuss for ages on that, and none of those analogies are perfect. But they all say something which is interesting, and I think the comparison with oil, for instance, is interesting in the sense that it stresses the fact that data today is an asset with value, and that there is a new industry behind it, and that's the industry which extracts the data, which refines the data, which deliver on different pipes the data, and then it's used by consumers. Okay, now what is more sure today is that there is a flood of data. Here utilize, as you can see, some kind of outreach presentation by Intel. I don't know whether the numbers that are there fit with the existing situation, but obviously we have in different space quite a lot of data that is exchanged, shared, or not always shared with everybody, but at least a lot of data is provided in different contexts, obviously, including smart factories and cloud providers today, especially with the sanitary crisis, are obviously exchange a lot of data. And as a reminder, and sorry to be a little bit basic, I'm professor sometimes, it's easy to start with some definitions. So I like the definition of Rob Kitchen of big data that you can see now. It refers to, the big volumes, it's vast quantities of data, but it's a data that is dynamic, and there are as well very varied data which are on the ICT networks. They are definitely linked with the ICT networks. The data is conjoined, shared, distributed along those networks. And we have new tools to analyze those huge amounts of data. We are not living in a universe of data scarcity today. No, there is data abundance, and we need new data analytics tools to extract some value out of the data, because the value might be in the data, but it's not a value that is obvious. You have to extract some information or even knowledge from that data, and that's a long process which requires to use sometimes very sophisticated tools of data analytics. Okay, so as you know, the three main V's, but according to others there are 4 or 5 V's, but volume, variety, and velocity characterize big data. Again, I'm not sure the numbers here about the data flows that are currently exchanged in 1 minute and that you can see on this table are still correct, but that representations focuses on personal data, of course. If you think about the amount of data flowing on Facebook, on YouTube, and on the other platforms that you can see here. That's probably mainly personal data, but people tend, of course, to forget that we have huge data sets containing non-personal data. And I'm just referring here to a page of Airbus. And as you can see there, they are stressing the amount of data that is just provided by a flight. At the time they were writing this page in 2018, there were 25,000 parameters of a flight, and per hour of flight, more than 10 gigabytes of data are collected or were collected at that time. And that's why a company like Airbus wants to share some of this data, not with Boeing probably, but they want to share it because many other players can be interested in the access to the Airbus data sources, and they are advocating some type of data sharing there. Now, I don't know how far it goes in the case of Airbus, but obviously the objective of the Commission is to incentivize more data sharing beyond the one that a company like Airbus is voluntarily doing. So my presentation will be on data sharing after those introductory slides. I will focus on non-personal data, which obviously are different and the opposite than personal data. The relation between non-personal data and confidential or open data is more complicated. I will tackle some of those issues, and I will focus on the B2B context. But data sharing is as well important in other contexts, like into B2C context, as well into B2G, G for government. There will be a presentation after the pause by Professor Alemano on that particular issue that I won't tackle. I will make a reference to one of the tools that we have to enhance data sharing between platforms and businesses. So there is as well an access P2B. And when you think about some of the tools like the portability right, you would see that the data sharing is in a longer sequence, because that's from a business to a consumer and then to another business. That's about what portability involves as a type of data sharing. And I will, of course, focus on data sharing within the EU. There are two dimensions of the notion of data sharing, which is not a legal one. It's really a policy notion, this notion of data sharing. It implies access and it implies use. And that's why we'll see that IP, intellectual property rights, have a say, of course, because usually IP rights at least control the use of some protected assets, and they can as well control the access to those assets. So that's my outline. I will first discuss the main types of data, and sorry for some of you, it's probably so obvious that you can skip it, and then I'll see how we have already in the existing data regulation some rules or at least incentives for data sharing. And in the last part, which is in a sense my conclusion, I will open the discussion for new instruments that might be adopted for incentivizing data sharing. Okay, legal types, that is probably known, but when you consider all the data regulation, and I'll list some of the main instruments that we already have at EU level, you see that there are four main types from a legal point of view of data. There is open data, which is basically synonymous with public data. And that is, of course, some type of data that is in principle opposed to confidential data. Confidential data is protected by confidentiality and in particular by the Trade Secret Directive. So that's a binôme. They are opposed. Personal data is, of course, the focus of the GDPR. Nothing new there. As you know, there are already some instruments on the sharing or the free flow of non-personal data. But let's go a little bit more into the definitions of those main types of data. And here I've copied the definition of Article 4.1 of personal data from the GDPR. So personal data means information, as you know, relating to an identified or identifiable natural person. So it's only about individuals, and as you know, the GDPR creates some rights in favor of individuals, natural persons. And as you know, it's very broad. When we think, for instance, about some smart object, like connected or in the future autonomous cars, obviously they generate a lot of data, and much of this data is personal. The position of the car, the direction of travel, the journey history, the speed data, the type of use of the brakes, and so on, might be personal data and have implications, for instance, for the liability of the driver. But this information is not necessarily personal. It can be anonymized, and in this case, it escapes the application of the GDPR. But anonymization is complex, as you as well know. It requires to aggregate the data to a level where you cannot identify individuals anymore. And with the different possibilities of combining data source, it becomes very complicated. But there are still some data that, of course, might at the origin relate to an individual and later become anonymized. For instance, if we refer to cars, I mean, when you say, as a policy expert on transport, then on Mondays, more than 60% of cars use a special trajectory from other days. That's obviously anonymous information, but which might be created on the basis of personal data, if it's based at least on the data generated by connected cars. The free flow of non-personal data regulation as a second important instrument when we are dealing with data sharing. That concerns non-personal data. It's a legal term, but obviously in other contexts or in other countries, people would refer to industrial, technical, or machine-generated data. There is no positive definition, and that's a problem maybe of non-personal data. It's just the opposite of personal data. And as the definition of personal data has no very clear boundaries, at least it's flexible, so is the same with the category of non-personal data. There are some examples in this important regulation, like, for instance, if you have aggregated data sets based on big data analytics tools like aggregate data on the numbers of COVID contamination, again, the information, the data was maybe personal at some point, but when it's anonymized and aggregated, it becomes non-personal data. You have, of course, many other examples. So the problem in practice is that we have mixed data sets, combining personal and non-personal data. In this case, according to free flow of non-personal data regulation and the guidance that the Commission has produced, the free flow of data regulation applies to the non-personal part of the data set and the GDPR to the rest. But in practice, you cannot, most of the time, distinguish the two parts of the data sets. The data are inextricably linked. And in this case, again, to GDPR to apply, which creates, of course, heavy burdens. And the question I have here is how to deal from a legal point of view with mixed data sets. The guidance issued by the Commission in 2019 on the free flow of data regulation correctly assessed that those mixed data sets are the majority of data sets, in principle GDPR. But I think here that we have to adopt a risk-based approach concerning the identification of personal data. It's only if there are reasonable likelihood that the data can be linked to an individual that the GDPR should apply. So we should accept some residual risk of identification. Otherwise, I think it makes life probably too complicated. But it's clearly a notion that is dynamic, and it depends on the evolution of data analytics tools, on the possibilities to associate, to mine data, and of course, the new AI tools will change as well the situation. We should as well take into account link to the data sharing or the data use in order to assess how to deal with mixed data sets. And in general, as well, I think that's my problem with the GDPR. I think it doesn't put enough the prejudice or the harm aspect at the center of the regulation. And we should pay attention to that. Of course, if there is a prejudice, possible prejudice, then the GDPR should clearly apply, but we should take more attention to that aspects. I will be very quick because that's a little bit outside my presentation on open data. And that's a data about, that's a directive about the data which public authorities have and produce. I hope you can still hear me. I do pause here, and you can have a look at the definitions.
We can hear you, Alain. That's not a problem. That's not only your the camera is frozen, but don't worry, it's not a problem. We will ask you to reconnect after your speech, but everybody can hear you, no problem.
Okay. The camera is frozen. Okay.
Yes, it's a problem of connection, internet connection. But don't worry, it's not really important because we see your we can see your PowerPoint. So I think
okay, good. And I hope you can hear me at least.
Yes, definitely we can.
Okay, so in the Open Data Directive, then the concept there is different because that's an instrument about the transparency of public documents. So the concept is the concept of documents you have here, the notion. And of course, there are some exceptions, like always, there is an attempt, of course, to incentivize public authorities to share their data and as well to make it possible for third parties to reuse this data, even for commercial purposes. But of course, sometimes the documents might include elements that are protected by intellectual property rights of third parties or confidential information, and then you have an exception in this framework. Now, the Trade Secret Directive, that's about confidential data. Obviously, that's the opposite of open data. But a trade secret is some form of information. Here you have the definition of trade secret in that directive. So it's an information that is secret, that has commercial value because it is confidential. And of course, there is a requirement for the trade secret holder to take some reasonable steps, otherwise he cannot enjoy the protection of trade secrets. Let's move to the next issue, because here I discussed the four main types of data. Time is passing. Let's move to data sharing. And obviously, data sharing is the opposite of data appropriation. I'll say more on that in the existing data regulation. We could discuss for ages about the qualification of data by economists. As you know, they consider data as non-rival, and that's, I think, quite clear for data consumption. The fact that one user uses data does not imply that another user or consumer is prohibited from using it. And in that sense, data is non-rival. Data collection is not rival in theory, because different entities can collect the same data most of the time, except in certain circumstances, like in the McGill case that some of you, at least the competition lawyers among you, know, which led to a decision of the Court of Justice in 1995, a long time ago, where at that time the data involved was only owned by the broadcasters. So you had a case of unique source. There was no possibility for McGill to access or to collect the data except through the broadcasters. But we have other instances where the collection of data becomes rival, because some companies have a special position which allows them to collect data from users and from third parties as well. Of course, you understand already from which companies I'm referring to. So in that case, because data becomes rival, there are some justification for some intervention in order to promote more data sharing. And I've added here a quote from Eric Schmidt, the former CEO of Google, at the time when Google was not the big company we have today, and the people at the top of the company were more talkative than today. At least at that time, Eric Schmidt underlined the fact that the big amounts of data and the possibility of scaling is what makes Google different than many other companies. So in terms of collecting data, they have the possibility to scale their operation, and that has been underlined by the Department of Justice in the complaint that was released last week. But on top of the rivalry aspect, data remains excludable, and that's important. It is possible to exclude third parties, and that's what I call data appropriation. And data appropriation can be made by different ways. And if we apply, I will do it very quickly, about the data generated by autonomous or connected cars. Again, I don't know whether this information is correct or not, but at least those cars, the connected cars of today, already generate a lot of data per day. Data, of course, and it's one example of the Internet of Things, can have value for many different actors. Well, obviously, for the manufacturers, they can improve the cars through getting access to that. For the providers of the data sensors, like the LiDAR or the cameras and sensors that are implemented into cars. It's important as well for the insurers. They can offer contracts, pay as you drive, if they have more data. Car distributors and repairs might as well benefit for care maintenance of accessing this data. There might be as well many new service providers who could serve ads, and we might have other assistance service. This data might be important for to road managers, including public transport ministries. And it's important for us lawyers to assess the liability. Of course, the data that is contained in what could be the black box of the cars, like the black box of aircrafts, might be relevant. So we have, in fact, many different actors, and I think it's a good example where the sharing of data might create new activities or new businesses, or at least some improvement in the way different businesses, including legal services, are performed. So there are good arguments for facilitating data sharing. So in that case, manufacturers should not appropriate all the data, but they can appropriate the car-generated data. And as you probably know, and at least I've written several times on what I call the data appropriation triangle. So companies, but individuals as well, but mainly companies use three main ways to appropriate data. Property rights, and in particular intellectual property rights. There is no intellectual property right on data as such, but you can use, for instance, the protection of database. We could talk about that. There are, and I think that's more important, contractual means, so agreements. For instance, if we refer to the car, that would be the agreement between the manufacturer and the user of the car. And there are, of course, technological and practical measures to weigh the data from the cars is collected and sent to a server that might be a server of the manufacturer. Then he will be able to appropriate this data. But if you have another standard for sharing the data, not through a private cloud of the manufacturer, you could facilitate data sharing. So you have, I think, in all or in most instances, three possibilities. And in fact, when you look at how people react in practice, they put forward the technological measures of protection or the contractual terms as the main ways to appropriate data and to be protected. Here, that's the result of a survey concerning database makers. So it's not data providers, it's database makers. And for them, obviously, you should look at the violet color, technological protection measures, TPM, first line, and contractual terms are the most important ways to protect themselves and to appropriate their databases. Copyright and the sui generis right on database and unfair competition law play a minor role. And I think it's the case in many other instances. So we shouldn't pay too much attention to the property rights. I'm an intellectual property lawyer, so I can say that. Now, when we look at the data regulation framework, it contains many instruments. And here I've just listed in this cloud some ex-ante ways to regulate data. I'll come back on some of those instruments. And I spoke already on some of them. But that's only the horizontal instruments. And in fact, you have as well a lot of sectoral instruments already. And I'm reusing here a table from a white paper that was prepared in 2017. I think that was more or less the year when this discussion on data sharing started. And obviously you have different instruments for the different sectors: transport, spatial, financial service, environment, pharmaceuticals, chemicals. There was a reference during the discussion about REACH and the kind of data ownership well, there are as well requirements to share data according to REACH, but it's a limited sharing. So in all those instruments, you have possibilities to share data, but as well to appropriate data. And when you look at the main instruments, some of them reinforce data appropriation. And it's clearly the case of the Trade Secret Directive and the Database Directive. On the other side, you have instruments like the Open Data Directive or the exception for text and data mining. TDM stands for text and data mining in the Copyright in the Digital Single Market Directive. Text and data mining is a way to access data and facilitates data sharing. Other instruments are a little bit in between, like here you see the GDPR or the free flow of data regulation. The GDPR creates a possibility for individuals to control their own data. So it's a reinforcement of data appropriation, and that was an objective because we are dealing here with a fundamental right. The free flow of non-personal data regulation is probably more in the direction of facilitating data sharing, and so on. I think we could have a continuous and analyze the different instruments. I think time is passing. I'm already after half an hour. So maybe I will leave the analysis of those different instruments. In the case, for instance, of the GDPR, the right to data portability in favor of individuals is an important way to enhance data sharing. And we could discuss, but I'll leave it maybe for the discussion. Data portability, according to the GDPR, Article 20, takes place more into B2C, 2B context. So you get the data from the data giver as a consumer, and then you can reuse the data with another platform, for instance, which is then the data seeker. That's a B2C, 2B access. There is as well data portability into B2B context, but that's only where it's technically feasible. So it's less strong because the individual is not involved in that case in Article 22. So I think portability is important. It gives some control in favor of individuals, and that facilitates the sharing back to the user or to a third party. But there are limitations, of course, and I cannot go into the details. We could discuss that more. When you look at the free flow of non-personal data regulation, first of all, that's a reminder of a communication of the Commission of 2017 that you might remember, building a European data economy. There, the Commission wanted to go quite far. Because they were considering the creation of a new data producer right. That would be really data ownership, but that was abandoned later when the Commission came with the draft free flow of data regulation. And in that case, there is an imposition of free flow of non-personal data. So the objective is to have a fifth freedom, the freedom for non-personal data to circulate within the EU. We don't have a right to data portability, contrary to GDPR, but the EU encouraged the porting of data, for instance, through the development of self-regulatory codes of conduct, best practices, the possibility to switch from providers in order to avoid some locking effect. And there are some other pushes there, probably, that's my guess. The future initiatives of the Commission will build on those instruments and do more than the free flow of non-personal data regulation. I won't discuss about the copyright in the Digital Single Market Directive, but it's important, the exception for text and data mining. You have a definition there. And at the end of the process, as you might know, two different types of text and data mining exceptions, one for research purposes and the other one for other beneficiaries, were adopted. I don't think that goes far enough, but at least it's a good way forwards in incentivizing some form of sharing of data. But that's more the copyright field. Let's then conclude with my third part towards new instruments for data sharing. Now, when we look back when this discussion started, and I think it was more or less in those years when The Economist, for instance, came with this issue in May 2017 about the role of data, but of course, they were not only underlying the value of data, but as well, of course, the fact that you had big platforms like the oil platforms, which were extracting most of the data. So since then, I think the discussion has been focused a lot on data and platforms, and then as well on the competition issues. Obviously, if we discuss the issue of platforms. And as you know, the platform to business regulation that came into force in July this year, but was adopted in 2019, concerning the relation between the providers of online intermediation services and business, comes with some transparency requirements. For instance, there is an obligation for the platforms to provide an explanation in their terms of use to the business about the scope, nature, and conditions of the platform access to personal or other data, to the personal or other data generated by the businesses using the platform. So it's in favor of the platforms and in favor of the business users to have access. And of course, that is an attempt to reinforce data sharing in this space, the platform to business space. But there is no obligation to share data or give access to third parties. There is as well no prohibition for the platform to use the data for self-favoring practices. But of course, that might fall under competition law, and we know the case involving Amazon, which, according to some people, use some data to favor its own products, the data that they can access on the platforms that they offer as a marketplace. So I think that more should be done for aggregation by platforms, but that should probably be the focus either of competition law or regulation applying to large data aggregator. When you look at the EU data strategy, that's a vision, and that is about means to facilitate data sharing beyond platforms, because the Commission thinks that a data-driven society is important, wants to facilitate access, and what will come out of that, we'll see. It's probably not for me to say. The Data Act has been already mentioned. Instruments to reinforce B2B or B2G data sharing might be on the table. And I think as well there should be some review on some IPR instruments. The Database Directive, if not the Trade Secret Directive, to facilitate some access to data. There will be a focus on sectoral data governance, as you know, that has been already discussed within certain common European data space. My view, and that's my last slide, sorry for being too long, is that probably we need in Europe to more experiment and invest in data sharing cases rather than to regulate at least concerning the B2B access. Maybe some regulation is necessary when you look at data sharing in the platform to business context. And maybe we have to devise new institutional models for some of the data space. The open banking program into UK might be a pragmatic and interesting examples where you have the development of some common and open application programming interface. You have an independent new body created, controlled by a regulatory authority, in this case, the Competition and Market Authority. And that might be maybe a good example. I would like to hear from you if you know more about that. I'm not an expert. But I think we should have, and we should experiment dedicated clouds for practicing data sharing in different data space. And that's important, how to organize those spaces. Probably some standards and some specific data governance tools have to be adopted, for instance, concerning security, quality of data, interoperability. That should be included by design in those spaces. Open data should probably be proposed for certain sub-data sets. And the Commission or the public authorities in general should use carrot and sticks to find a balance between the temptations of data appropriation, including by confidentiality, and the data sharing objective. And thanks for your attention.